Last week, we discussed the different methods for obtaining information necessary to pursue a lawsuit. After that information is obtained, the next step in the litigation process is the preparation and filing of the initial pleadings. In this video, we'll be covering the nature and purpose of pleadings and the elements and formats of a complaint. We will also look at a real-life complaint that was filed in a lawsuit called Sutanovich versus Dubie, which will be helpful in completing project number 1, which involves drafting a complaint. A pleading is a document filed in a court proceeding that defines the nature of the dispute between the parties. Pleadings are filed with the court to initiate the lawsuit. A complaint is a document that a plaintiff files to initiate the lawsuit, and the defendant files a pleading in response to the complaint, which is called an answer. A defendant may file other claims against the plaintiff or other defendants or third parties. If necessary, the plaintiff, co-defendant, or third parties may file a reply to the defendant's claims against them. The initial pleading that a plaintiff prepares and files is generally known as a complaint, or in some cases, a petition. This document starts the court proceeding. The complaint is the pleading in which the plaintiff states a basis for the lawsuit. Generally, the complaint does the following. It identifies the plaintiffs and defendants in the lawsuit and describes their status and capacity to sue and be sued. It also contains a statement showing that the court in which it is filed has proper jurisdiction and venue. It also describes the factual basis for the lawsuit and requests or demands some relief from the court. The Hawaii Rules of Civil Procedure contain rules specifically addressing the format of a complaint. Rule 8 of the Hawaii Rules of Civil Procedure provide that a pleading shall contain a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for judgment for the relief the pleader seeks. The format of a complaint requires a caption, which is the part of the complaint that identifies the court in which the complaint is filed. The allegations and cause of action section provide a description of the parties, statement showing proper jurisdiction and venue, the factual basis for the lawsuit, and a description of the loss or damages incurred. Towards the end of the complaint is the prayer or wherefore clauses, where the plaintiff requests relief or some type of remedy from the court. The signature block is where the attorney signs the document. This is an example of what the caption of the complaint looks like. The caption should include the name of the parties, the name of the court, and the case number. It should remain the same in future pleadings filed in the case. The parties named in the lawsuit should be the real parties in interest, or the individuals who are entitled to the relief sought in the complaint. You should also identify whether the parties are being sued individually or whether the party is a corporation. It is important that the parties bringing the lawsuit or that are being sued have the capacity to be sued. Minors and incompetents need to have a representative to represent their legal interests. The complaint in any action must contain some allegation showing that the lawsuit is being filed in the proper court. This involves questions of both jurisdiction and venue. In a complaint filed in federal court, these allegations are usually very specific. In showing jurisdiction, the plaintiff states why the action is filed in federal court, giving a citation to the appropriate United States Code section. In state courts, jurisdiction is determined by state law. In federal or state courts, venue can be determined by a number of factors. The most common factor is the residence of the defendant. Proper venue can be shown in the complaint by an allegation that one of the defendants resides in the district in which the action is filed. Venue is also proper in the place where the cause of action arose. Therefore, another common way of establishing venue is by alleging that the cause of action arose in the district in which the action is filed. However, there are many different ways to establish venue. Although the complaint usually follows certain legal technicalities, it is primarily a document that shows the factual basis for the lawsuit. It does not contain any discussion or analysis of legal theories. However, when reviewing the facts that are alleged in the complaint, the defendant's attorney and the court should be able to tell that there is a legal basis for the lawsuit, even though the legal basis need not be expressly stated in the complaint. How detailed this factual description must be depends on the jurisdiction in which the lawsuit is filed. For most types of cases, the complaint must contain sufficient facts to put the defendant on notice as to why he is being sued, but it is not essential that each element of the cause of action be supported by factual allegations. This method of pleading is known as notice pleading. Hawaii is a notice pleading state. Every complaint filed in an action contains a demand for relief from the court, often called a prayer. Courts have the power to grant two different types of relief: money damages and equitable relief. Money damages means the award of money to the plaintiff as compensation for some loss. These damages are known as compensatory damages. Special damages are actual out-of-pocket expenses incurred by the plaintiffs, whereas general damages include such things as pain and suffering and do not compensate plaintiff for actual out-of-pocket damages, although they do compensate the plaintiff for some type of loss. Punitive damages are meant to punish the defendant and are awarded only when the defendant has committed some extremely offensive act. The standard in Hawaii for the award of punitive damages is willful and wanton conduct on the part of the defendant. In the course of any lawsuit, the parties inevitably incur substantial expenses or costs. These include such items as filing fees, process server fees, deposition fees, and expert witness fees. Costs are not included in computing plaintiff's damages. However, if the plaintiff wins her lawsuit, she will generally be awarded certain costs in addition to the actual damages. Equitable relief in contract law involves a court ordering the defendant to do something or to stop doing something other than simply paying money damages. Specific performance is an order requiring a party to perform a contract. Rescission is an order rescinding or voiding a contract. Restitution is an order to return money or property, usually paid in connection with a contract that was subsequently rescinded. Declaratory relief is a court order defining or explaining the rights and obligations of parties under some contract or other document. Quiet title is an order clarifying ownership of real property, and an injunction is an order requiring a party to stop doing something. After the complaint is drafted, it is typically the paralegal's responsibility to ensure that the complaint is filed with the court. Filing with the court means giving the document to the court clerk to be recorded in the docket. The court clerk will usually stamp the complaint to show proof that the document was submitted. The court clerk will then assign a docket number or case number. All subsequent pleadings must include the docket number. Federal courts and some state courts allow documents to be filed electronically. Federal courts use the Public Access to Court Electronic Records or PACER system, which allows the public to access court records, and the case management and electronic case files is used to file documents. Each state court has its own rules and procedures. Hawaii Appellate Court records can be accessed and filed electronically. Hawaii Circuit Court records, however, cannot be filed electronically. However, certain case pleadings can be accessed for a small fee. At the time the complaint is filed, the court issues a summons. A summons is a form explaining that the defendant has been sued and should answer the complaint by a certain date. Issuance of the summons simply involves the clerk of the court affixing his or her signature to the form. The defendant in any lawsuit is entitled to receive notice of the action. This is accomplished by service of process. A copy of the summons and a copy of the complaint must be delivered to the defendant. It is the plaintiff's responsibility, rather than the court's, to see that the defendant is properly served. It is important to ensure that the complaint is properly served. A common method of service is personal service of process. Some rules allow for the complaint to be left with a competent adult at the defendant's residence. Some states also allow papers to be served by mail, or in some cases by publication. When personal service cannot be accomplished, appropriate laws must be reviewed to determine alternatives. A defendant is encouraged to waive formal service of process. The rule sets out a procedure to be followed to accomplish this. The plaintiff sends by first-class mail the complaint, the notice explaining the process of waiver, and a waiver form for defendant to sign. If the defendant refuses to waive service, the court can impose on the defendant the cost of subsequent service. Sometimes a complaint needs to be amended. Most jurisdictions view the rules of pleading very liberally. No court is interested in seeing a party lose a case because of some technical deficiency in the pleadings that could be easily corrected. As long as an amendment does not drastically alter the nature of the case or cause any undue hardship to the defendant or delay in the case, it will probably be allowed. Under the rules, the plaintiff is allowed to amend the complaint once as a matter of right within 21 days after the responsive pleading or motion is filed. The parties may also agree to allow the plaintiff to amend the complaint through stipulation. If the complaint is amended, the new document is entitled First Amended Complaint, assuming this is the First Amendment. For statute of limitations purposes, the amended complaint usually relates back to the original date of filing of the original complaint. Now the link here will take you to the sample complaint forms provided by the Hawaii State Judiciary. So if you click on the link here, you scroll to the bottom, you'll see sample complaints. So complaint on a promissory note, complaint on an account, complaint for goods sold and delivered. And so you'll see the samples here, as well as a sample format of a complaint. Now let's look at a real-life complaint that was filed. It involved a woman named Geraldine Cvitanovich, a co-founder of the diet company Herbalife, and a man she married named George Dubie. According to Cvitanovich, Dubie swept her off her feet and allegedly told her that he was a self-made millionaire and famous movie producer. Unbeknownst to Cvitanovich, however, she claimed Dubie was a former cult leader and had a checkered past. Dubie allegedly told Cvitanovich that he had supernatural powers and that he was in contact with a Satguru named Swami. As a result of Dubie's alleged representations to Cvitanovich, Cvitanovich and Dubie divorced and transferred millions of dollars to Dubie via a trust and property settlement agreement. When Dubie was in Thailand, he was killed by his ex-girlfriend. This is when Cvitanovich allegedly realized that Dubie had other women in his life and that she was conned into transferring her assets to him. Cvitanovich sought to set aside her divorce decree and property settlement agreement on the basis that the divorce decree was null and void. Cvitanovich argued that Dubie was previously married and had obtained a quickie divorce in the Dominican Republic from his prior wife, which Cvitanovich alleged was not valid. The Hawaii Supreme Court upheld the validity of the property settlement agreement. Based on the facts previously provided, here are the causes of actions alleged in the Cvitanovich versus Dubie complaint. You'll see here that the different causes of actions include undue influence, fraud, duress, conversion, breach of fiduciary duty, constructive trust, negligence, intentional infliction of emotional distress, negligent infliction of emotional distress, restitution, rescission, attorney's fees, and punitive damages. Now in the Resources folder and Project subfolder, you will find the Project Number 1 memo and supplemental materials. After reviewing the memo and materials, your assignment is to draft a complaint using the sample complaint template provided. You may also refer to the Cvitanovich versus Dubie complaint as a reference. Thank you for watching, and please proceed with completing this week's activities.